Now, how do automatic disqualification clauses work, and are they effective from a family law perspective?
Yeah, this is a really interesting one. Many of the trusts that we establish and a number of other law firms establish will contain a provision in them that we call an automatic disqualification provision, which is where someone in a key role, whether it's an appointor or a trustee, will get automatically removed from that role upon a certain event happening to them. The most common scenario is incapacity. If you've got a trustee who becomes incapacitated or dies, then obviously they need to be removed and someone else needs to step into that role to manage the trust. But those triggering events can also include a family law breakdown. So we can have a clause in our trust deed or our will saying that if the appointor or the trustee separates from their spouse, then they automatically get disqualified from that control role and somebody else steps in their place. Now, I'm not aware of any instances where that has been tested before the court. I think it's got reasonable grounds of being successful if it is tested. And we, as a rule of thumb, include those provisions in all of our documents on the basis that the worst case scenario, if it gets enacted, is no worse than what they would otherwise be facing. So if we don't have it in there, that individual is going to stay in that control role. We'll have all these tests around purpose, control and source. At least if we've got this automatic disqualification, we've got a fighting shot and there's a possibility that it will get them across the line on that control test on the basis that they didn't actually make that change themselves.